those people who have been able to come along at this time in the conference, and Dr. Niteesh, lovely to see you online as well. Today I'm basically I'm controversially named this, you can't teach people to be ethical. I'll go into why I've controversially called it that in more detail in a second, but I guess as I'll just go back to the start there. So my name's Anneka Ferguson. I'm a senior lecturer at the University of New South Wales in the practical legal training program, which is attached to the Faculty of Law and Criminology, as we are now. So I particularly teach into that space where students have, in Australia, students complete their undergraduate degree or JD in law, and then they need to do this practical legal training before they can get admitted to the courts for practice. I'm also a legal practitioner myself as well. Yes, you wanted to know, you wanted me to introduce my hobbies. I had just put it in there as a sideline. I do it to my students as well. So in my spare time, I like to drive rally cars on dirt through the forest. And most of the time I keep them right side up and don't end up in ditches. But that's just my hobby. I always just do that to try and deflect from the image of the staid lawyer or whatever with students, but it's always a conversation starter with other people as well. So just for today, I'm just going to look into this statement that I made controversially, that you can't teach people to be ethical, through the lens of behavioural ethics. Briefly look at what we do teach, but I'm not going to spend a huge amount of time on that because that's not the focus of the presentation today. And then the focus is going to be what I have seen as the themes that have developed as we've been, as I've been teaching the Giving Voice to Values curriculum. And the reason why I'm looking at this is when we ask ourselves what we need to teach students in order to be ethical in practice, I'm often like to start with a different question. Instead of just asking what we should be teaching them, part of the equation of assisting students to feel that they are empowered to act ethically is understanding how they view the profession, their place in the profession, and the types of conflicts that they think that they will encounter, the types of ethical conflicts that they think they encounter. And by understanding this viewpoint enables us to facilitate teaching opportunities that meet them where they are at and hopefully make them feel a bit more empowered to act ethically when they are in practice. Why would we consider this approach doing this differently, and why do we need to understand what they think about the legal profession going into it? And I guess I sort of come from a background where I'm quite enamored by this idea of behavioral ethics. Increasingly, research suggests that, as sort of Haidt says, teaching people to be moral philosophers or to enhance their character actually doesn't improve their ability to take ethical action. So instead, through the lens of behavioural ethics, is based on this understanding of the cognitive limitations, social and organisational pressures, and situational factors which make it hard for even well-intentioned people to act as ethically as they would like. So by taking into consideration the environment that our graduates will be working in or are working in legal practice, and even how they view that environment, we can start to give them better tools for taking ethical action in that environment, rather than just discussing how you would make an ethical decision. To do this, we lean very, very heavily on Mary Gentili's Giving Voice to Values curriculum. I'm not going to go into a huge amount of detail on this. A lot of people know it already for good reason. It's a really valuable curriculum. It starts from this different starting question of, once I know what I think is right, how do I get it done? And it's about building moral muscle memory and about giving people the choice to act because they know they can take action, rather than simply saying, you know, the right thing to do, try and work out how to do it. So as part of this curriculum and the way we have adapted the curriculum to the legal environment, and I encourage you to go and have a look up online if you haven't already been introduced to Giving Voice to Values, some fabulous resources online. It's an open share curriculum, so if anybody wants to use it, you're welcome. Contact Mary or contact Boredom where she is based, and you can access any of the resources there. But as part of that curriculum, what we do when we're getting them to practice how to take ethical action with our students is we actually ask them to bring hypothetical ethical conflict scenarios to the table. So rather than us giving them the scenarios and saying, this is the scenario you have to work through, we actually ask them to bring the scenarios to us. And over the years that I've done this, and it's thousands and thousands of scenarios I've seen, because I did it at my previous workplace, which is at the Australian National University as well. A thematic analysis of the scenarios that students bring into this practice space provides an insight into their experiences in the profession. So far, if they have placements, so some of our students are already working in the profession or they've got placements in the profession. It also gives some really interesting insights, even for those who are not already working in the profession, on the way they view the profession and the things that they are most afraid of encountering ethically. So one of the things that they do when we set them as challenges, they particularly like to try and bring scenarios to the table, to the practice space, that they think there is no ethical solution to. They like to sort of challenge us with this when they come in to challenge us and say, this is an ethical problem. It comes up in practice. There is no way we know how to deal with this. And then we'd spend the time working through that scenario and actually providing them with ways to think about how to work through that. And this allows them to stretch their muscle for dealing with the circumstances. So, there's a whole presentation in how we do that, but that's actually not really what I wanted to focus on. What I wanted to focus on was the kinds of assumptions that students make about legal practice that is evident from the scenarios they bring to the table. So, for example, their hypothetical scenarios often demonstrate these assumptions that I've got in here, that legal practice is hierarchical, okay, which is often profoundly true, but they bring that assumption to the table. That their supervisors in legal practice are unbending and unyielding. Unapproachable is another way of saying it. They come with an assumption that the profession is unethical. Okay, they come to that lawyers are expected to be sneaky and unethical. They come with the assumption that speaking up is frowned upon by the profession, and that the client supremacy, so what the client says goes. They also come with an assumption that they have this fabulous desire for social justice and they know what is right, and they will have to exercise that desire for social justice and what is right against the world, including the profession. So they're not joining a profession that's going to allow them to exercise that's sort of how it is. They also controversially I think come to the idea that when they enter the profession as newcomers, they have nothing to contribute, ethically or otherwise. There is also sometimes the assumptions that ethics is just about the rules. Just read the rules and find the loopholes so that you can do what you want to do. And they also assume that legal practice is always adversarial. So it's always involves a fight against the other side. So those are the sort of the themes that we see in the kinds of scenarios that they bring to the table. So these assumptions lead to the following assumptions when ethical conflicts arise. So they assume, because of the fact that they assume that their supervisor is bending, unyielding, etc. They assume that to be submissive to one's superiors is to be respectful. And that's completely submissive, as in you do exactly what you're told without questioning them ever. And there's certainly a cultural aspect to that for some of our students, but there is also, for those students who don't have that as part of their culture, it is still actually assumed that to be submissive to one's superiors is to be respectful. They also assume that as newcomers to the profession, they have no power to enforce ethical action. They have to ask permission to do the right thing. They will not be listened to if they do speak up about unethical situations. They also come to the table with this idea that unethical behaviour is intentional, rational, and thought through, which from behavioural ethics, we know not to always be the case. Sometimes unethical behaviour just accidentally happens. It's taking the eye off the ball. They also come to the table with this idea that sort of the, supervisors, colleagues who behave unethically once are completely unethical all the time. They cannot be trusted. So in their view, as soon as somebody has done something unethical, that's it, that person is written off from their ethical mindset for quite some time. They also, following on from this, think that supervisors and colleagues who instruct you to take unethical action are unethical people. So this comes along with this idea that they are conscious that what they are asking you to do is unethical and that they will insist on being obeyed. They also come along with the assumption that if you do encounter an ethical conflict, to speak up is to lose your job. So there is no middle ground for them. If you speak up about an unethical situation, you will immediately lose your job. There's that catastrophizing that happens there. But then the other side of that is that if you face an unethical situation, you have to take a stand to be heard. You have to be adversarial and aggressive in that space. So, and then you've got the fact that as a bystander to unethical behaviour, they don't think they have any power to do anything. And they also assume that being unethical will assist their client and that all ethical conflicts are insurmountable and catastrophic. The only option when you encounter an unethical situation in practice, by the way they set up these scenarios, is to leave, right? There's no middle ground. So, I mean, this sounds pretty over the top, I think, in sometimes, but I guess it's important to understand that these are some of the things, and it may not be the case in our other jurisdictions, but these are some of the assumptions they're making about ethics and the practical and the legal profession that they think they're going into. Now, not all students are making all of these assumptions, and because of the space in which we're asking them to do this, which is to bring an ethical conflict to the table, obviously we're only seeing the ethically conflicted lens in these themes, but it is still an insight into where they think they're going to see problems. So going on from that sort of extension to how they view the profession, their place in the profession, the most common ethical problems they bring to the table are around these things. Time billing. They have worried about too much time being added, time being recorded by people who are not doing work, charging clients with deep pockets more, and should they bill for their learning time? So they're concerned about the fact that when they start in practice, they're going to need to understand aspects and whether they should bill for their learning time. They're very concerned about being asked to lie for a client and or lying for a client to enhance their case. Ignoring confessions, witness coaching, inappropriate discovery patterns. They're very worried about supervisor pressure to do the wrong thing. And that comes as an extension of that hierarchy that I was talking about earlier. So they very often frame the problems as being told to do the wrong thing rather than encountering a situation they have to act ethically in. This comes up interestingly, breaching confidentiality in social situations. So either colleagues doing this in public places, at work functions, or uni friends that are now work colleagues in social situations. They also grapple with the concept of loyalty. So loyalty between themselves and their peers, supervisors, firms, clients, and even loyalty between their personal and professional selves, including their cultural and familial loyalty. They also really worried about the long hours that they believe to be expected in practice, and that it needs to be like that constantly to succeed. And also not being allowed or empowered to say no to work, to their superiors, to their clients. They were also very worried about disrespectful communication. I know that there was a panel on harassment in the profession, either directly to them from supervisors, colleagues, or clients in the workplace, or observing being included in such disrespectful communication. They were also worried about failing legal practices who cut corners to make money to bolster a practice that is failing. And that often comes out in things like trust account monies being misused, etc. And they're also worried about conflicts between former and current clients, and even conflicts in small communities. So how you deal with issues of conflict when you work in a small community or belong to a small community. So basically sort of putting these kind of assumptions about the legal profession, students' assumptions about their ethical position in law, and the behavioural ethics factors that are at play in the associated ethical problems. Sort of, I just present this as an example. So if we look at the assumption about the legal profession, that it's hierarchical and that it's inherently unethical. By framing the profession as innately hierarchical in their minds, which frankly is not far wrong in quite a lot of law firms, students are setting themselves up to blindly follow their superiors and their ethical behaviour. But this does also still worry them, because their assumptions about lawyers and the legal profession is that they are unethical. So we know from research such as that by Tang, Holmes and Foley here in Australia, that the ethical climate of a graduate's first law firm can set them up for their careers and for their satisfaction with staying in practice. And yet we would suggest that an element of why this is the case is because students expect and or experience a hierarchical culture and equate submission to the requests of superiors as respect. Students can also inadvertently fall into the trap in a hierarchical culture of asking permission to do the right thing, the same way that they put all of their work through their supervisors, superiors to be checked when they're a junior in a firm. So one example that really struck me was actually in a discussion on a scenario like this with a graduate who worked already in one of the big law firms in Australia. And they sort of put this ethical situation on the table. And I must say, I kind of looked at it and went, you just do the right thing. Like, it wasn't a particularly difficult situation, right? You just do the right thing. And when I said this to the student, remember, you don't have to ask permission from your superiors to do the right thing. The student, who was a very intelligent, very capable student, came back to me at the end of the conference and said they found that this was really powerful because they'd only been working in this large law firm for 4 weeks, but they'd got so used to sending all of their work to be checked before it was sent out that they just defaulted in their own minds to sending their ethics to be checked as well. So as an extension of this belief assumption about how practice works, this means that they're being asked, they fear being asked to lie for a client and having to just do it in order to build their careers in practice. And they often forget that the Australian Solicitors' Conduct Rules, for example, particularly pertains to them individually. So it doesn't relate to organisations or firms. And they forget all that critical thinking for themselves that they were supposed to have been encouraged to complete at university, almost instantaneously, in some cases, walking into practice. So that's sort of one example. So there's this obedience to authority, this way they frame legal practice, and there's also an overconfidence bias that they're more ethical than everybody else. So just delving into this concept that the profession is inherently unethical a bit further, this then leads them to make these assumptions that being unethical is required to assist your client, it is them against the profession, and that unethical behaviour is intentional. And so the associated ethical problems with that is being asked to lie for a client and supervisor pressure to be unethical rather than support to be ethical. And then a final sort of example of how this plays up is this other assumption about the legal profession is speaking up is frowned upon. So when they inherently in their scenarios they bring to the table suggest that, if they speak up, they're going to lose their job. But then at the same time, if you have to take a stand to be heard, and that as a bystander, you have no power. And so the associated ethical problems with that are not being allowed to say no, being asked to do anything unethical, and not being able to speak up when you notice an unethical approach. And a lot of this is around the organisational pressures, also the way they're framing their role in the legal profession, and also not wanting to rock the status quo. So I guess I leave, rather than solving all of this, what I just sort of leave is the question around examining this question of how graduates, these are students who are either already starting to work in practice or are just about to start in practice. What does this mean for how we facilitate ethical learning environments? Why would we care what the students think about what legal practice is? And I think my somewhat glib answer to that is we have to care, because if we don't understand how they're already, the messages they might have taken already from university about ethical practice, which is one part of this. So if they're approaching ethical practice like this, what are we doing when we're teaching them their undergraduate or their JD degrees that makes them believe, or is it media about, lawyers, that makes them think that this is what the practice of law is like? And how do we start to subvert that way of thinking about practice so that they feel that they might be empowered to take ethical action in practice? Now, we started by actually having the conversation, but I'd be intrigued by anybody else's views on that, and whether that at all relates to how you think your students see practice in your jurisdictions. So thank you very much. I didn't keep an eye on the time. I don't know how long I took. I apologise.
Great. Well, no, thank you, Anneka. That was great. And so now we will turn to Dr. Niteesh Kumar. And let's go ahead and turn the team. Do you have slides?
Good morning. Can you hear me?
Yes. Can you hear us?
Yeah, I can also hear you. Can you please give me the screen sharing, right? Because it's stating host disable attendee screen sharing.
All right, and you should be able to now.
Yeah. So thanks a lot for giving me this opportunity. This is around 4 a.m. in the morning, and my first time, honestly, speaking in the morning. So I don't know what kind of voice it may come to you people, but I hope I'll make myself clear with the topic. And so I'll introduce myself. I'm Dr. Niteesh Upadhyay. I'm an associate professor of law at Galgotias University. It's in India, a guest faculty at American Romanian University, Romania. And I'm also a member of Academic Friend Network of United Nations Human Rights Advisory Committee. So today I will be discussing on nurturing caring lawyers, rethinking research ethics and responsibility in India. When we are talking in terms of research, especially, we find that India is not in terms of, even if you look for publications and all, you will not in terms the best as we can do. We are not very good in terms of the quality of the research that we are doing. The basic objective of research is to increase the quantum of information and knowledge on any subject. But we are finding that there are a lot of people and a lot of researchers are doing certain activities which we could not is some kind of a plagiarism, falsification, and fabrication of data, which brings a bigger research ethics issue. When you ask what ethics is, I think it differs from country to country, person to person, institution to institution, and also with your level of education, the meaning of ethics also change. When we are doing research, so there are basically two set of research. These are some of the motivating factors of doing legal research. But there are two set of research that we do. One is doctrinal, other is non-doctrinal. So we use these methods. One is armchair research. So when you sit in a library and you do your research. Other is a field-based research where you go in field using various sampling and statistical tools. You try to figure out the outcome of research. For any good research, you require it to be correct, comprehensive, credible, and cost effective. When we are talking in terms of the first two, correct and comprehensive, correct very clearly states that whatever quantum of information and knowledge that you have gathered and you are reflecting in your research paper, thesis, or dissertation is not induced with plagiarism, falsification, and fabrication of data. When you are talking in terms of credible, there is no credibility of work. Most of these students are going to be lawyers in future, and if they cannot do a credible research now, I think there is going to be a problem when they're going to be in profession, when they're going to be advocates. So credibility is a lot in question, and I already told ethics may differ from people to people. It's basic moral principles, how you conduct an activity. Not just research activity, any activity that you conduct, it reflects your moral principles. So I will be discussing about research that I have done. I'm doing since last almost 4 years at different private and public institutions. So I have myself taught at almost 4 universities in last 5 years. Checked almost 600 to 700 student projects, annual projects related to research paper writing on different topics. So I have taken a sample size of 258 students projects, and these projects are checked on the software of Turnitin and Unkun. And I can tell you how this goes about that there is a problem when we are talking in terms of the first draft. So this research, this pie chart reflects the first draft submitted by students. These all are post undergraduate students. So mostly third and fourth year law students. In India, the law degree is for 5 years. So there are senior students of third and fourth year. And I'm teaching them human rights, international humanitarian law, refugee law. So we are basically discussing a lot on very sensitive issues related to trafficking, related to prostitution and all. And they are submitting the research papers on these topics. So when we are talking of, when we have taken this sample of 258 students, around when we have put this work, the research paper on Turnitin, there were 45 students whose paper have more than 80% of plagiarism. I can say it was a verbatim plagiarism. They have not even taken any work or any kind of conscious to remove the amount of or the content that they are copying or they are using from anybody else's article. So they are not attributing. Some of these people are also providing footnotes, attributing, but they are verbatim, word to word, similar to the work of any previous author. There are around.
Oh, I'm sorry to interrupt you. Are you advancing slides from slide to slide? Because we're just seeing your title slide and not the slides aren't advancing. So I just wanted to double check.
Oh, sure, just wait. Extremely sorry. I think I have missed a lot of things then in that way. You could have interrupted me a little early. No problem. Thank you. Can you see the slide now? Research ethics and doctrinal research.
Yes. Yeah. We're seeing slide 8 right now. It looks like it's still in perhaps in the editing mode as opposed to in the presentation mode.
Yeah, it's in the presentation mode. Can you see the research ethics and doctrinal research slide?
Yes, we can. Yep.
Okay, thanks a lot. So around 60% 62 students have copied more than 60% of the text. So basically, they were involved in mosaic plagiarism. And there are around 30% of the students have done some kind of a plagiarism using mosaic plagiarism. They have also done verbatim plagiarism. Some of them are also involved in self plagiarism. So they have published an article earlier, and from that article, they have copied. In India, self plagiarism is also a problem according to University Grant Commission of India. So they have done self plagiarism. There are only, if you say that what are the percentage of the paper that you find are good and on ethical standards. So there are not more than 31 papers out of 258 student projects and papers that were submitted to me, which have less than 10% plagiarism or similarity index. So this is a big problem. Doctoral research in India, most of the time, this is kind of a force. So people are not doing it voluntary, to be honest. They are forced because they have marks attached to it. So once they submit these projects to us, once we mark them, they can go to the next class. So this is not a kind of a voluntary activity that they are supposed to do. This is a forced by the university administration. As a faculty, I think that every student have a different level of understanding of things and also way of reflecting. There may be certain students who are not very good at research and writing maybe, but they're very good in terms of giving and conducting workshops and training programs. Maybe we can have a embedded, or maybe we can have a multi-dimensional project system where student can choose what kind of work they want to do, and maybe then they will be doing it ethically. When we are forcing them to write projects and research papers, they are tend to make mistakes, tend to find out shortcuts, and then submit the reports which are plagiarized to us. There is a serious concern when we are talking of research ethics in empirical research. Can you see my PPT, research
Yes.
ethics and empirical research? Oh, thanks.
Yeah, we're seeing slide 9.
Okay, thank you. So when we're talking in terms of research ethics and empirical research, I have taken a sample size of 50 dissertations of various private and public university scholars, basically their first draft. Because when you are submitting an LLM, after every draft, your plagiarism reports will be sent to you, plagiarism report will be sent to you, and you have to reduce it to less than 30% to get it selected for private universities, and maybe 20% and when you want your dissertation to be selected for a public university. So again and again, your university will ask you to reduce the similarity index that is there, but there are other problems. I'm not just discussing about in this particular slide about plagiarism, but I'm also discussing about other issues related to empirical research. So there are, I have checked on data, how many of them have more than 40% of plagiarism in their research in their first draft. So there are out of 50, there are 12 students who have more than 40% of the material is plagiarized, is copied from somewhere. There is a similarity index. Also, the next issue is sample size of research less than 50. Some of the students are working on topic related to, let's take domestic abuse, misuse of cyber, or human trafficking. When they are working on sensitive topic, gathering data is very tough. So they create a very small sample size, which has ethical issues that when you reflect from a very small sample size, then your universe, the result regarding your universe may not be correct, may not be authenticated. So they have to increase the number of the sample size, but because of the paucity of the time, India also started after looking at international university, the LLM program for 1 year. They are still in deliberation, and a court case is going on in Supreme Court of India discussing that we can have a mandatory 2 years LLM program rather than 1 year LLM program, because student gets very less time to focus on the research. So sample size is a big issue. Sometimes students work on issues which gathering sample is very easy, but they restrict themselves to a very small sample size. The next issue is related to falsification and fabrication of data. So when they are working on a sensitive topic, one of my students was working on a topic on which I have done my PhD, and I did a empirical research. The topic was bright trafficking in state of Haryana, a small state in India where, because of the poverty stricken areas around, and because of female killing or female feticide and infanticide, the sex ratio is very less, and the people in Haryana are forced to buy women for purpose of marriage. So in that case, a student is doing her dissertation on this same topic, and when I asked which person you went, whom you met, she had no answer. She directly took some things from my research unknowingly, and this was a time of pandemic when she does not know that I'm his teacher, and this is my own work. She also copied some text from my one of the colleagues' work, and she presented as if it's her own empirical research. When I asked that how you gathered this data, she said that I have got this data through Google Forms. And to be very honest, as I have done a field research on this particular topic, interviewed almost more than 300 drug trafficking victims, most of them are illiterates. Not even they have their primary education, they cannot read and write. Having an email account to fill a Google form is almost impossible. Also, I have found that during her article, she is taking certain contents from my work, but she is editing the footnote and mentioning some other authors. So she is also fabricating in a way that it does not look that she has copied a lot of content from my research paper. So falsification and fabrication always being a big issue when you're talking in terms of research ethics. These people are going to be teachers in future, especially the people who are doing their postgraduate. They're going to be professors, assistant professors, associate professors. The students who are undergraduate, they're going to be lawyers. And this is one of the major problems that I have encountered, that whether we are talking of undergraduate or postgraduate students, the basic ethical misconducts remain same. So whenever sensitive topics come, there are topics on which doing a research becomes tough. They try to create some kind of a shortcut for themselves by doing a plagiarism, falsification, and fabrication of data. So in the basic research concept, it said garbage in, garbage out. So when you put garbage in, the only result will be garbage out. The next is many institutions teach statistical techniques to their students, but have no proper classes or no proper instruction on ethical standards or ethics of research. They will teach in Vogo, SPSS, but they will have no class on ethics of legal research or ethics of research. Also, there is a long-term problem with students understanding a difference between qualitative and quantitative methods. And when they are doing empirical research, they tend to mix both of them and confuse not just themselves, but also the guides and the people who are reading their research papers. There are also issues related to self-enforced obstacles for interdisciplinary research, because many institutions in India are asking that students should do some research which are of interdisciplinary nature. So I'm also a guide to a student who is doing a research on artificial intelligence, bioforensic, and law. So there are students who are doing interdisciplinary research, and they create their topic in such a way, they select a title in such a way that doing a research becomes tough. And later on, then they come to a point where they have to copy things from other sources and just somehow manage their work in the time frame, the deadlines, and submit it to the authorities. So now, what is the role of law teachers in ethical research? Discuss with the student about plagiarism, have a zero tolerance policy for the same. The next I would like to discuss more, be the example, discuss importance of research ethics in legal profession, and gives a hands-on training to for data gathering. When I'm telling that be the example, I tell you, I have also seen, and that data is not reflected in my PPT. I sometimes review papers in some of the journals with which I am working as assistant editors, associate editors. These papers are mostly by law professors. And the same problem that I could find in an undergraduate or a postgraduate level paper, same problem I'm finding in papers of professors. If they are not being taught and trained how to avoid plagiarism, falsification, fabrication of data, how we expect that they will transfer the ethical conducts of research to their students? I got to know from one of my colleagues that she submitted a paper for a book, for an edited book, where there are around 25 other authors submitted paper. And her paper was a little lengthy. Everybody else's paper was around 15 to 20 papers. This woman has done a PhD, so she has a little bigger paper in terms of pages, which is around 35 pages. The author of the book has cut it short without even asking her and place her paper in 15 pages and use the other 20 pages on the name of some other author without taking permission. It looks weird. I can see the expression, but yeah, this happens. And I could see a book, and if somebody wants, I can click the pictures and I can send. I don't think there is any defamation when you are stating something which is correct. So I can share with you all. There is a book which is an edited book, but it looks like it's authored. It's a self-authored book. You go on the front page. Let's take it's written by me. You go on the front page. You'll find Dr. Niteesh Upadhyay. You go in the index page. You will find, okay, chapter 1 discusses this. Chapter 2 discusses this. There is no mention of the people who are contributing the chapter except on the pages in which they have their articles. So there is a kind of a practice that this book should look that it is written by me. There is nowhere it is written that it is an edited book or edited by. The front page states authored by. And this book is hardly 150 pages. And to be honest, this book is discussing about research ethics. So problem is that people who tend to be the solutions are the problems. People who are under an authority, under a responsibility to train their students about research ethics are making these mistakes. There is a recent trend, I'll just take 2 more minutes and I'll finish my presentation. There is a recent trend in India that most of the university and institutions are only considering Scopus, Web of Science, and SCI for promotions. And there is a race in India, I tell you. And this race is to get Scopus publication. I got 3 in last 3 years, that's all. But I know people who have got 6 in 1 year. And if you go and check their author's profile, you will not find a single article named on their author's profile in Scopus. So there are a lot of these predatory journals. Students as well as teachers are paying off to get published. Once their article is published, they show in their resume, CV, and biodata that we have published so and so. But when you go on the Scopus website, you will not find any article listed on their name. So there are issues. In India, there are a lot of academicians, to be honest, and I think there needs to be a better regulation in terms of this pay and publish culture, that there should be no promotion if you are doing so. And there should be certain kind of a mechanism which checks also the ethical conducts of the people who are publishing books and journals. So I think the major issue is not with the students. So when I say this is a first draft, why I use as a first draft? Because then I have to do a hard work to make sure the students who are doing verbatim plagiarism of around 80% has to reduce their paper, their plagiarism level to 20% and do ethical research. So first, as a professor, I have to understand the importance of ethics and research, and then I can transfer that to my students. And paying and publishing, removing names of the authors, making your book look like that it is your self-authored books. I think uh, it's not just a problem of copyright, but it's a bigger problem of ethics in terms of research. And also, we are talking of legal research. All these people already understand, people who are doing research about copyright and other issues, and they are making mistakes. So we should be more accountable. And if there are certain punishment, we should be more, the punishment, the gravity of punishment should be more for us. So with this, thank you very much. If there is any question, I will be happy to.
All right, thank you. I think we'll save questions till the end. And so I'll go ahead and share my screen. Great. Okay, so my name is Caroline Wick. I am a practitioner in residence at American University, Washington College of Law in Washington, D.C. I'm essentially a fellow, and I teach in the Disability Rights Law Clinic. So I'm entering my third year, and I'm sorry, I can take this off. You might be able to hear me a little bit better. In my first year, I just taught in the clinic, taught and supervised students, and then in my second year, I get to teach a second class. And so I was teaching legal ethics. I decided to teach legal ethics. And up until that point, my training had all been in clinical pedagogy and in teaching a 14-person class. But in my law school, legal ethics classes are capped at 65. So it's much bigger and a very different teaching style. But I knew that I wanted my clinical pedagogy to inform my legal ethics teaching. And in the clinic, because it's 14 students, we're very interactive. We're teaching skills and values. So we're teaching interviewing and counseling and fact investigation. And so I wanted to incorporate some of that into legal ethics despite the class size. So, for as many of you know, when you are in a large class in the US, typically the way it's taught is with the Socratic method. So one teacher engaging with one student. But we know from research that that is only one teaching method and that students learn from a variety of different ways. And so students have a variety of different learning styles, and I wanted to incorporate various learning styles. We also know that students get bored. And so if we use the same teaching mode for too long, they're going to move on and they're going to stop paying attention, especially when they have laptops at their fingertips and cell phones. And then we also know that they have short attention spans. And so one study I read said that undergraduates have an attention span of about 10 minutes. Maybe we can expect a little bit more from law students, fingers crossed, but maybe not. And so if we want to keep them engaged, then we have to be changing our activities throughout the class or throughout the course. And they'll pay more attention if we are doing that change throughout the class. And we also know, and one of the reasons that I specifically wanted to incorporate interactive exercises is that students are more likely to walk away with a deeper understanding of the material when they've been actively engaged in class. So we also know that there's a hierarchy of thinking and that a hierarchy of levels of thinking, and that remembering and understanding are on the lower levels, whereas evaluating and creating are at the higher levels, and that we want to incorporate activities that target different levels of thinking in our classes. And so that was another goal of mine as I prepared legal ethics. And then finally, kind of a final goal for me as I was thinking about designing my legal ethics class was to bring in teaching fundamental skills and values in the legal ethics class, and especially skills. So the ABA studied the legal profession's values and wrote a report, the McCrate report, which many are familiar with, that established 10 skills and 4 values that lawyers should possess when they enter the legal profession. And some of those skills are such that I thought I could include them in legal ethics, like legal research, oral communication, and written communication. So, as I mentioned, I really wanted my 62-person legal ethics class to be interactive and to increase participation for all students in the course. So to not just engage with one student, and that in that way I felt I could keep them engaged with the material and assess their understanding. So I'll go through just some of the exercises that I used. By no means do I think I'm an authority on this at all, but I'm sharing my experiences. So one thing that I did from the beginning, based on recommendations of colleagues, was that I used the Lerman, Schrag, and Rubinson textbook, which is a problem-based textbook. And the problems are actual ethical conundrums that attorneys have encountered in practice. And the problems ask the students to put themselves in the place of the lawyers and then decide how they would respond. So the problems are not yes, no questions, but instead, for example, a problem might say that a lawyer received an altered drug test from a lab. Is it ethical for that lawyer to then present that to the court? And the students have to debate it applying the ethical rules. And so what I would do, which was suggested in the teacher's manual, it worked beautifully, was to ask the students to prepare the questions ahead of time and then ask them to discuss that in groups during class. But given that I was assigning these problems for each class, it was repetitive to only have the students discuss the problems in groups. And so sometimes I would ask the students for individual comments just to break things up a little bit. The other thing that I would do is I would use different colored cards. So the light gray reflects versus the black reflect different small groups. And when the students would do the discussions in small groups, one way to make the discussion more entertaining was to ask them to hold up a red card if they would answer no, and then a green card if they would answer yes. Not rocket science here by any means, but it was a way of starting the conversation around their responses to the problems. And then also some students reported that they liked this exercise because they were able to see the variation among their colleagues, so they could look around and see, okay, who's responding how. I liked it for the same reason, because I could see the divide in the class, and then some students would hold up red and green cards, so it got to that kind of variation. Some students said that they thought it was confusing, so you can't win always, but that was one way in which I tried to vary things. That another way, this came from another legal ethics class in my law school, but I would ask the students to stand up if they agreed and to remain seated if they didn't. And this was another way to incorporate all students in the classroom. For some reason, I think too, incorporating movement really just gets the students excited. And for those who have zoned out and are focused on their laptops, all of a sudden they're like, what is going on in this classroom? And so it was another way to incorporate all of the 62 students. And again, it was another way for the students to see the variation amongst themselves. And then another thing I did specifically with the problem-based method is for those problems that were a little bit complex, we had some financial regulation type problems and other problems that the students were like, whoa, this is too much. I gave them worksheets to fill out in the groups. And I think there was a feeling amongst the students that it almost it caused them to take it a little bit more seriously, take the group work a little bit more seriously, and to put their best foot forward. And then I would collect, they would work together to figure out the answers. I don't know, for some reason, just having a worksheet in front of them was a little bit inspiring for them. I will say that some students both in mid-semester, I collected mid-semester feedback from them, and then also the course evaluations, of course. They thought that the handouts and the worksheets made it feel a little bit like a high school class. So again, you can't win, but for those students who wanted to engage with the material by writing, that was an option for them. The other thing is, as a result of that feedback, I did start saying to the students, these worksheets are optional, or the handouts are optional. I'll talk about the handouts in a second. So next I turn to activities that incorporated fundamental lawyering skills. So one thing that I did was to ask the students to do short legal research assignments. So in the first class, we talked about ABA Model Rule 8.4G, which prohibits harassment and discrimination based on a number of protected statuses. So I broke the students into groups and I said, could you choose one of 3 states, Virginia, Maryland, or DC, where my law school is located. We have 2 states next to us, and DC is a state for these purposes. And so they could choose, the students in their small groups could choose which state, and then they went and I asked them to look to see if ABA Model Rule 8.4G had been adopted in their state of choice. And it just so happened that it worked out that each state had adopted a different version of the rule. And so it was pretty great. We were online and I went into one room and this student just had this crestfallen face. And I was like, what happened? And she said, Virginia didn't adopt it. I said, I know. So, but it was fun to see them. And, I know this is pretty basic. I mean, is it right to qualify or to legal research as looking up a state's rule, but having taught in the clinic, I recognize that some students don't appreciate that the ABA model rules are just that, they're model rules. And so they get into the clinic and they're like, I checked the model rule and we can contact you. And you're like, no, no. So this was something to do early on to emphasize that each state has its own rule. Later, in the course, I asked the students to research a question, the DC ethics opinion, related to, I should have double checked, but I think it was related to retention of client files at the end of a case. And it turns out that me just saying, go look at the DC ethics opinions wasn't enough. And I needed to kind of explain what those were and where to find them and that kind of thing. So there were some lessons learned there, but I was hoping that would help them realize that there are other sources of ethics laws other than the rules. Another kind of two other activities I did to incorporate fundamental lawyering skills was when we talked about joint representation, I asked the students to work in their small groups to draft a letter to a client explaining the challenge or the potential pitfalls of joint representation or the potential challenges. And then I also, when we talked about confidentiality, this is something we do in the clinic, I asked them to come up with an explanation of confidentiality to the client or to a prospective client. Both of these activities require the students to create content, so fall kind of at the top of the Bloom's hierarchy of thinking. You know, I think these worked and they were good for this. You know, I think it was I appreciated the activities. I think, and I'll talk a little bit at the end, but I think I tried to do too much in my class and didn't always, you know, maybe gave these surface level treatment as opposed to the deep treatment that they deserved, or really to do it well. You know, you could spend a whole class on drafting a letter to a client about the challenges of joint representation. You know, some activity, so moving on, these next activities I kind of put under the both preventing boredom and also incorporating as many students in the class as possible. So one thing I did was include a TV show clip. I showed a clip from The Thing About Pam, where a prosecutor was giving her closing argument and pretty flagrantly violated the rules of professional conduct. And, you know, I was surprised the students really seemed to like this. And I think I don't know, I'm not a psychologist, but if I were, I would suggest that it was, that it kind of gets at their want to say, like, I'm part of the in crowd now, and I know that that's a violation, and they want to go to their friends and say, like, that's a violation of the rules. I mean, I know I was like that as a law student. So they really engaged with the clip much more than I expected them to. And then I also played a clip from a podcast. There was a daily episode where the host, it's a daily podcast, but interviews an attorney the host interviews a reporter who overheard two of the Trump White House attorneys talking about their strategy in response to a request for documents. Yes, also a flagrant violation of the rules, and the students seem to enjoy that as well. But I think that really does fall on I mean, it gets at it's just not me talking, it's someone else talking. So that's nice for the class, but so I think that was fun. And then I mentioned that I gave kind of handouts to work through the problems in doing the small group problems. I also would give them handouts for lectures that were a little bit more difficult to follow. So 1.8 is the model rule. 1.8 covers 10 specific scenarios with respect to current conflicts, and I gave them a chart to follow along. Again, I think this is helpful for some students to follow. For others, like I said, they thought it felt like high school. And then another thing that I did to involve the students is sometimes I just wanted to check for their understanding, especially for those rules that are most straightforward. And so I would put up a question, and this came from it's not unique to me, plenty of people do it, but would put a question on the slide and then have 4 answer choices, and then ask the students to put up a finger to represent which answer choice they chose. So this is what it can look like. And this one was fun for me because you would see the students like kind of do this. And again, you know, it was nice because the students could look around and see what their colleagues were selecting, and then gave me a baseline to see where they were at. And then finally, at the end of the course, we did a negotiation simulation, and we started the class, and the students just looked at me like they were just so bored. I did some lecture at the start, and then they were going to break out into these and go into different rooms to do the negotiation. And I can't emphasize enough the distinction between the start of class and the end of class. They came back from the negotiation and they were lively and they were shouting, and we talked about what happened in the negotiation. And it was, I mean, it was more, I don't know if it was more than night and day. It was fantastic. And one of them walked in and said, "I hope you do this every class." That was amazing. So they really liked being in the position of the lawyer. And there, you know, so those are some of the things that I did. I guess some of my concerns are that with this idea of making legal ethics fun, am I trivializing the subject of legal ethics? And I don't want students to think that it isn't a serious subject, or that we shouldn't be treating it with dignity, respect. But at the same time, I do want them engaged and involved. And so, I know from my evaluations that at least one student would have preferred the Socratic method. So always good to keep that in mind. And moving forward, I'll be sure to explain what my class is and what it isn't. Another question is, really, how do I know if I've succeeded? And I think it depends on what you're trying to measure in terms of success. In general, I think I prevented boredom and kept students engaged. One student commented on his evaluation, "This course was not as dry as I expected it to be." So I count that as a win. But other students said much more great things, but that was one of my favorites. And then also, so that's one aspect of what I was trying to measure, but did the students learn what I hoped they would? And there, I think that's harder to measure. Again, I get a sense of this from the evaluations. A student commented, "I learned a lot about legal ethics and the difference between my morals and ethical duties." And like, that was just, I don't know, that was like a very nice thing for me to read. And I felt like, okay, I've succeeded. So, but did I transfer the other knowledge that I hoped? I didn't ask for their MPRE scores, nor do I necessarily feel that that was a good indicator. But that's something I'm thinking about moving forward. And then, as I mentioned, sometimes I felt like I tried to do too much in one particular class, or kind of glided over subjects that maybe deserved a more thorough treatment. And so I'm going to be teaching ethics to 1Ls in the spring, and my law school teaches it as a elective for 1Ls. And I'm a little, I think that's even more challenging than this course, I think, because the 1Ls come in with, they're stressed and they're anxious, and they are, they also have even less context. My students this year, some of them were doing internships, or they had their summer experiences. So, but anyway, I'm looking forward to refining the course. And I'm also really interested, in what works and doesn't work in your classes. And this is my email address, so I'd be happy to talk to anybody. I would love to hear what you do in your courses, because we're all fighting the battle against laptops. So, so with that, I will turn it over. And
Thank you. I appreciate the opportunity to share with you some ideas about Mexico. We are close, but in some aspects we are so far. So the name of my paper is Ethical Competencies, a path for the teaching of professional ethics in Mexico. I am part of the Universidad Panamericana. Universidad Panamericana is a private school, and we are in Mexico City, Guadalajara, and Aguascalientes. I work at Guadalajara. I am full-time professor, and in Mexico, we have identified only 4 full-time professors who are doing research about legal ethics. So that is a privilege in my country. So the objective is to explore how law schools can incorporate the teaching of legal ethics through a competency-based education model. I have divided my participation into 3 sections. The first one, a little bit about competency-based education. I know that there are a lot of material about this, but it's important to understand this in the Mexican context. And the second one about the teaching of legal ethics in Mexico, because this is an international panel, and I want that you understand the context of the profession. And the third one, the viability of teaching legal ethics as a competency in Mexico. So, which is the starting point? The starting point could be obvious for the audience, but it's not obvious for Mexico, that it's my real audience, and for the students. So first, we need to highlight that the university has a very important social role that it must assume with all the responsibility that entails. Once again, bearing in mind the contribution of education to the possibility of democratic citizenship, universities must seek to train moral agents who are capable of recognizing the great implications of their actions in society, especially in the performance of a given profession. This is not obvious in all the universities in Mexico, but for the Universidad Panamericana, this is important. So the Universidad Panamericana is one of the universities that professional ethics is a mandatory course, not only for lawyers, or for all the majors. That is the reason why I am part of the Humanities department, because we decided that professional ethics should be part of this department, because what happens is that before each academic area said, okay, ethics is very important, but what happens in everyday life, that they decided that it could be more interesting, the technical aspects or the knowledge, and they always leave ethics at as less important. So we have a commitment with legal ethics and professional ethics in general. So we consider that ethics should be present in legal education, and we are aware about something that Martha Nussbaum, an important philosopher, I am a mix of lawyer and philosopher, has mentioned about what is happening nowadays with humanities. And people consider that sometimes humanities and ethics is a useless ornament. So also an important philosopher of law, Luigi Ferraioli, has mentioned why it's very important ethics for the legal education. So the first thing that we need to mention to other schools when we discuss this topic is that is the utility of the legal ethics. That's something that it could be obvious in other contexts. More about the Mexican context. Okay, we have minimal regulation of legal education. We have minimal regulation of the profession. We have a lack of consensus on the scope of professional ethics. We need to answer, what do we mean by professional ethics? Something that it could be obvious, for example, in this country. And also we need to answer, what do we mean by legal ethics? I don't know if you know that in Mexico, we have more than 2,000 schools of law, okay? And only 170 schools are certified because it's not mandatory. So imagine the gap between those elite schools and the majority of the school, because if you want to open a law school, you only need to pay like $500 and you get the permission, okay? And you don't have difficult requirements to open a law school. That is the context of the education in Mexico. And as I know that you are aware that we are worried about the rule of law in Mexico. For example, the World Justice Project mentioned that what is happening in the country, a weakening of institutional checks and balances on state governments, and a closing of civic space, a deterioration in criminal justice system, and a lack of progress in anti-corruption. This is the fourth exercise of the World Justice Project. It's interesting, but the results we're worried about. So we need to face the challenge of defining a common goal to promote ethical practice. And we have been working at the university with that. We think that competency-based education, it could be the next step to promote faster this. And we have seen the difference between the philosophical approach and the competency-based approach, because imagine if you don't have rules, what is that? And yesterday we were talking a little bit about this, because I think that is something that we can find in Latin America, not only in Mexico, that if you don't have rules, sometimes the philosophers come to the class and they explain interesting things, but we think this is not necessary and we don't have time. So as we understand the philosophy approach at my university is that it's applied ethics, and there is a big difference because competencies have their origin in psychology. In contrast, applied ethics is a part of the philosophy. Also, competencies focus on acting and applied ethics is a normative science that seeks to develop maxims of action in the subject. That transcends mere acting. It is also interested in the purpose of the action and the circumstances in which the agent carry out the action. So here, as the third participant mentioned, also we have been exploring the behavioral science, because we think, okay, if we have an approach from a philosophical perspective, sometimes we think that that beliefs can origin specific changes, but not always that happens. So we need also to explore that. So we have been following particularly all the research that Hamilton has been working in the state with the Holland Center for Ethical Leadership, and there we are following this this professor and with these statements, okay, that law school should help students, and I will read the first one, to develop a specific core competence. So we consider that ethics, it could be one of the most important competencies that we need to develop in our students. So we see a lot of benefits with these approaches of understanding understanding ethics as a competency, because we consider that is something that now higher education is incorporating. This is not a new approach. Also, because we consider that it's a vehicle to promote ethical behavior. Also, because it could be studied in a cross-cutting manner. And the feedback that we have received is that is something that students and also employers say, okay, go ahead, it could be something interesting. So before implementing this at Universidad Panamericana, we analyzed 6 universities in Guadalajara area. The Universidad Panamericana, of course, that is my university, the UNIVA, the ITESO, Tecnológico de Monterrey, Universidad Autónoma de Guadalajara, y la Universidad de Guadalajara. And what we analyze with this university is we analyze the moral language that they include in 3 levels. First, the mission values. Second, the principles and values of profession. And third, each program of law that they have. Okay, so we divided the universities into 2 groups. The first group, we found UP, UNIVA, and ITESO, that they include in their mission, vision, and principles a link with that religious morality, specifically with Christianity, although each one in a different way, okay? But there is something that they have in common. And in the second group appear the institutions that are not linked to a religious morality, but it was interesting the different approach to the mission and values. So I want to skip to the last part, That is how the ethical approach is in each of the different universities. So, for example, in Universidad Panamericana, we, as I mentioned at the beginning, for us is very important, and we mention ethical sense. But if you can see, the purpose is not reading everything, but if you can see, we identify moral aspects, but there are different aspects. So we consider that the challenge with this approach to ethics is that we don't have enough data about competencies in the country. For example, if I see all that you have in the States about competencies in different fields, not only for private lawyers, and you have also for judiciary, and a lot of research that the Holland Center, for example, have about competencies. We say, oh, I would like to have that, but we need to move forward. We need to start. We need to do the first step, and we have established an action route. The first part is that we have established that we will our approach to ethics will be through a professional competency. Second, we need to define the components of ethical competency, because we are not sure if we are talking about one competency or we are talking about 2 or more competencies. So that's something that is interesting, but we will be working with that. We will establish a rubric that allows us to evaluate that competency, and the Holland Center work is useful for us. And we will establish the way in which it will be developed. We will document all the information, all the process, because it's a commitment with other universities and professors. And also we will be looking for feedback from different key actors. Also, we will be working with a strategic alliance, and that is more important, we will be overcome cultural barriers such as ideological ones to develop joint work. That is something that we have find not only in Mexico, in Latin America, that sometimes that is difficult, but our approach looks to try to solve that problem in order to improve profession. So this is a photo of Universidad Panamericana and some students, and thank you very much. I appreciate your patience.
So that's it for our plan, but we can take questions now, and I'll make sure we can see our Zoom participants. Sure.
So I'm curious about the admissions process in Mexico. So you have all these unaccredited law schools. Is there a bar exam? Is it divided by state? Is there a regulatory agency to whom aggrieved clients can take grievances?
No, okay.
None of that.
None of that. Only the Minister of Education give that permission that I mentioned, that you pay $500 and that it's enough. It could be federal, or it could be you can get that permission in each of the 32 states. Okay, but there are two organizations who are promoting with one of them with bar association regulate law schools. One of them, who I work close, is the CONAED, that it's a council which certify the schools. But what is the reality with that? That if that is not mandatory, only 170 schools from out of 2000 decided to follow the process. And with okay, that is the story with schools. But with professional, when you finish, depends of the school, the requirements. Because, for example, there is a test that if the school said you need to take the test, is called Ceneval. They say you need to take these points. But imagine if you are a small business school, they don't want that. Okay, so they say they finished, they took the courses, and after that they say you have the title and you are licensed to go outside and say, I am a lawyer, I need clients Okay, and that is the big problem that we have. And honestly, I have been working with the bar associations, with other non-governmental associations, and of course my school. We don't see that will change soon.
So you and 3 other people are going to reform the profession.
No, I don't know. I remember that the first time that I went to Minnesota to do my research, a summer program of my research, Professor Hamilton told me, Yurixhi, you are a one soldier. And I said, it doesn't matter, I enjoy my job. And okay, I can do what I can do.
Yeah.
So, I don't know if I can say all more questions to all of you. I really enjoyed the presentation. So I wanted to start with Caroline because I didn't know the TV series that you were mentioning.
The what?
The TV series that you mentioned.
Mhm.
And it got me thinking because something that happened to me was that I mentioned first I mentioned Atticus Finch, and it was like no one knew who Atticus Finch was, and it was like a blow to me.
Mhm.
Then I used Philadelphia. I
Yeah.
thought it's much more modern. The actors are still alive. The actors are famous, and nevertheless, they didn't know about Philadelphia.
Mm.
So what I'm trying to I just ended using How to Get Away with Murder and
Oh yeah.
so those are my two to go TV series. But I wanted to know what else do you use, and if you think that like we're approaching them too much, and they should also get to know all these old archetypes that are important
Oh yeah.
as a cultural image of our profession, or we just gotta get along with the wave and just like, so you like this?
So it's funny because I watch, like, I guess many people, I watch like police procedurals and other things, and I noticed the ethical violations. And then as I was teaching my class, I just couldn't find them. And so a thing about Pam happened to be a show that my mom had recommended. So I was like, okay, sure, I'll watch this. And it happened to demonstrate what I wanted, and and what I wanted to demonstrate for that particular class. I think that it actually worked fine. So actually out of 62 students admitted to knowing what the show was. Maybe others did, I don't know. But I think it worked out just fine that they didn't know what the show was, because all it was trying to do was demonstrate this violation of the rules. So I guess, it's funny, one of the speakers the other day brought up my cousin Vinny. We do use that in the clinic seminar because it does actually do a good job of demonstrating how to avoid you're an expert and other things. But I haven't thought that much. I didn't put that much thought, I guess is what I'm trying to say, into which show I used. I just happened to be watching this one show and it exemplified what I wanted to teach that particular day. So I guess I fall on the side of using whatever show is going to get the students engaged. And if Philadelphia engages them, then use that. And if it suits, then use that,
Okay. Then I have one for Anneka. It wasn't. I was surprised on how much because you said that your students bring the problems to the table, and I was so surprised that they knew so much. Like they knew about billing hours, and for me it was like, my students don't. I have to tell them that there are billing hours, and probably now they'll know, and they know it's an issue. But I was surprised, like how much your students know about it. And I don't know if you have like some course before, because I remember that in some Australian universities you have something like not legal ethics, but I don't know, just knowing society or legal profession and society. How do they get this previous knowledge that seems so important?
I think probably I'm at an advantage where we bring it in, we ask them to do this in that they've finished their law degree. A lot of them are in placements or they're about to go into legal practice. So they've already been interviewed, they've already been into legal practices a little bit, they understand that. But what's interesting is for some of the students, it represents what they're scared of. So they hear about time billing through through even undergraduate law practice. They hear about time billing, or they hear about it from their friends who've already started in work, or their perceptions of the law as hierarchical is purely from, you know, impressions that they've got from others and around about. So in fact, yeah, I can't answer your question about where they know all of this from. Some of them know it because they're in placements, but what intrigues me is what the people who have not gone into a legal practice yet, what they bring to the table, because it says what they think about legal practice at that point without having been in it.
Thank you. And for Yurixhi, I realized you made this religious division between the universities, but did that reflect on the legal ethics way of teaching or way of, or anything? Did it make a difference?
No, because we got all the information from their web pages. So I only summarized the results here, but we only see in which aspects all the information is related with moral decision. But we identify that there is a clear division, but we didn't get more information about explicitly what they are teaching as legal ethics, because they don't publish that.
All right, I think we're at time. So yeah,
Thank
thanks
you,
for everybody. Sorry that we got cut short on our discussion, and have a great day at work, Anneka, and sleep well. Dr. Niteesh. Bye.
Thank you very much, everybody. Okay.
Thanks, everyone. And I've also shared one of the conference link in the chat box if you're interested, especially the person who is interested into clinical legal education and all. So you can join. So just see the chat box. There is a link of Global Alliance Justice Education Conference. Hopefully I'll be there. So nice to see you there if you people are joining me in South Africa.
Yeah, thank you very much.
Today, thank you very much. And today is India's independent, you know, we celebrate
Happy
August.
Happy Independence Day.
Good morning, everyone. Hey, can I ask the host before you go? Can you allow multiple people to share screen before you take off?
Oh, sure.
Yeah, you just go to share screen and click multiple shares. Thank you so much for doing that.
Oh yeah, see you. All right, you should be all set.
Yeah, got it. Thank you so much for that. Thank you. Good morning from Singapore. Actually, you're all from Singapore. So I can, or you're in this region, so I can all say good morning to you. How are you? How are you? Thanks so much for joining the panel.
Thank you.
Yeah, one of our panelists, Maybelle Romero, is going to be the in-person chair. She got that by default, I think, because she's the only person actually at the conference. So we'll just wait for her to come in. So she's going to be kind of monitoring things on the ground.